Well, so we will now resume our discussion on the respect of procedural guarantees in content moderation on social media. And this session will be moderated by Pietro Ortolani. So Pietro, thank you very much for moderating this session, and the floor is yours.
Thank you so much, Florence. It's an absolute pleasure to do that. And indeed, we continue the discussion talking about these challenges of digitalization, due process, platformization, platform governance, looking at the EU DSA perspective, but also taking a look outside of the EU, in particular at Switzerland. And I will keep the presentations very brief. We have 3 excellent presentations lined up for you, and the speakers need no introduction, so I will very quickly just introduce their name, their affiliation, and give them the floor in turn, and then hopefully we'll have enough time for a nice debate and discussion afterwards. So our first speaker is Thibault Douville. Thibault is a professor at the University of Caen Normandie in private law, but he is also the co-director of the Institute on Legal Research at the same university and the director of the Master on Digital Law. So I cannot think of a better person to kickstart the debate. Thibault, you have the floor.
Thank you very much for this presentation, and thank you, Florence, for your invitation here in Neuchâtel. I'm very sorry, but I have decided, after listening the presentation of Pietro this morning, to change the title and the substance of my presentation this afternoon. I will speak about the role of the judge in contesting content moderation decision. What role does the judge play in the DSA? A very small one. To understand why the judge plays a small role in the DSA, let me do some reminders for beginning. The DSA doesn't provide general monitoring obligation. The DSA provides an exemption from liability for unlawful content disseminated. One exception is provided in the case of the online platform as an actual knowledge of illegal activity or content and doesn't act expeditiously to remove or to disable access to the illegal content upon obtaining such knowledge or awareness. At the same time, online platform, very large online platform, will have an obligation to analyze and manage risks as unlawful content, negative impact of content on the exercise of fundamental rights, on public safety, on gender-based violence. And platforms have the possibility to setting up voluntary own-initiative investigations. On this basis, online platforms moderate content using algorithms and human resources. In most cases, several layers of moderation are involved. In application, online platforms, on their own initiative, delete content, modify content hierarchies, demonetize content, suspend or delete accounts. In most of the cases, the system well functions, but it's a privatization of control over freedom of expression. That's not new. Let us think about the Google Spain judgment of the European Court of Justice about the right of erasure of links to websites and search engines. As in the GDPR, the privatization is fully integrated and enshrined in the DSA. The states, the member states of the European Union don't want to control, to moderate the content, don't have the resources to set up a moderation system, their own moderation system, and it's not their mission. How does the DSA regulate the moderation activity of the platform? To ensure the control of the moderation decision, European Union has, among other rules, put in place a procedure which is inspired in part by what certain platforms and social networks do. The procedure includes a part of self-regulation with an internal complaint handling system and a part of co-regulation too, with the implementation of a mechanism of alternative dispute resolution provided by a third party. How? And in this context, the judges are totally excluded from the DSA system. Please let me do some comments about this procedure, about the DSA procedure on contestation of moderation decision. The first question becomes, is the alternative dispute resolution the best way to settle disputes about the legality of content? Let me clarify the question. Alternative dispute resolution are mainly developed to solve disputes between consumers and professionals concerning the conformity of goods, let, delivery, etc. Under the DSA, alternative dispute resolution must take place in relation to illicit nature of information, which is very different from the performance of a sales or service contract. The discussion necessarily concerns the balance between freedom of expression, public's right to information, and rights to protection of personality and privacy. The discussion, therefore, focuses on the limits of freedom of expression and on what the parties accept as a limit. Some content is obviously illicit, while for others, we don't always know if it is. Moreover, the DSA gives authority to a previous amicable settlement of moderation decision. Finally, it's not certain that co-regulating the limits of freedom of expression is really satisfactory. In any event, the DSA doesn't mention the role of the judge in content moderation or contestation of content moderation decision. In any event, users are encouraged to use internal complaint handling system and alternative dispute resolution mechanism for contesting moderation decision for at least two reasons. The first one is symbolic. The DSA only refers to extrajudicial remedies, and each step of moderation decision contestation is presented as the continuation of the previous one, even if it's not legally the case. The second one is the implementation of this procedure by a very large online platform. We can add a third comment about the characteristic of the DSA remedies. The procedure is free, the cost weighing on platforms, and efficient. Obviously, it's not the case for the judge. The procedure is slow and costly. And previously, in case of cross-border situation, it's often the case, the competent court must be identified. In consequence, there is a risk of entrapment of the people in extrajudicial process for contesting moderation decisions. There is a risk of ineffectiveness of the right to an effective judicial remedy. And if a claim is finally filed with a judge, the case is filed in late, and the damage is often irremediable. At this stage, what can we conclude? On the one hand, European Union wants to regulate online platforms. On the other hand, European Union recognizes their own power of moderation, their power of moderation, including in the event of contestation of moderation decision. It therefore leaves plenty of room for self-regulation and co-regulation. The only real control exercised over platform is through verification of compliance with the risk management requirements by VELOPS. We need, nevertheless, to temper our words. The judicial and administrative authorities can issue injunction to remove content, but this power is effective for targeted speech such as terrorist speech or infringement of intellectual property rights, and not for all type of speech as hate speech or speech in a gray area. It's regrettable that the role of the judge for other type of content has not been strengthened by the DSA. The marginalization of the judge raises at least 5 comments. The standards used to moderate content are not specific to a legal tradition, culture, or states. As it has been said this morning, global standards are used, and there is fragmentation of state law. However, the balance of freedom and right depends from each state. It's up to state to define illegal content. It's up to them to define the balance between fundamental rights, but in practice, the judge has to do this balance. The judge is the legitimate actor to determine the legality of content and to protect speech rights and to guarantee other rights protection. One question that has been overlooked concerns the compliance of the general term and condition with freedom of expression. The judge should be required to review these general terms and conditions. We must not forget the right to an effective judicial remedy provided by the Charter of Fundamental Rights and the European Convention on Human Rights applies to a contestation of content moderation decision. It's not impossible to increase the intervention of the judge in contestation of moderation decisions. Indeed, this would only concern certain cases, essentially those which are in the gray zone. At this stage, another question becomes, how does the judge can play a role in challenging moderation decision? You probably think, after all, it's always possible to file a claim with a judge, and you are right. But litigation is currently limited before the courts. There are several possibilities of claims around moderation decision, as compensation claim following the maintaining unlawful content online, or claim for withdrawal lawful content, or for account deletion. The applicant can be the recipient of the service, as well as third parties, association, trusted signalers. So, what is provided for by the DSA about these possible judicial claims? Nothing at all. The DSA doesn't provide rules, for example, concerning the removal of unlawful content or for the infringement of terms and conditions with freedom of expression. Court action is not encouraged. The DSA does not provide any procedural or substantive rules concerning disputes with platforms. Private international law will apply to determine the competent jurisdiction and applicable law. There are no procedural rules, either as the regulation establishing a European small claims procedure. It's a big question. Nevertheless, this is an exception. The Article 54 of the DSA provides a right for compensation. But this article raises some questions. 3 comments can be made about it. The type of damages are broadly defined. All types of damages are concerned, including moral damage. That's good. The DSA speaks about an infringement to the obligation provided by the DSA. But should this infringement be considered as negligent or intentional? Under the GDPR, it is the case, but the DSA doesn't mention it. Is a simple infringement sufficient? But to which rule? In most cases, an infringement will involve an assessment of the legality of content. Third comment, my main comment, the scope of Article 54 is strictly limited to compensation. It doesn't cover contractual claims or requests to remove content. In this context, what can we conclude? By seeking to strengthen the regulation of platforms, the European Union has reinforced the power over content. of the platforms, even if the moderation decision is contested. So, how can we reintroduce the judge? Different ideas might be followed to reinforce the place of the judge. For example, it's possible to create private international law rules for online platforms. But what criterion should be chosen to determine whether a moderation decision will belong to one legal system or to another? It's also possible to work on the organization of jurisdiction. It's possible to create online national jurisdiction in each state member of the European Union, which should be competent for disputes related to online platforms. The applicable procedure could also be adapted for certain types of disputes. For example, forms could be set up as for the small claim procedure about withdrawal decision, demonetize decision, or account suspension decision. I don't know if the good solution is one of these proposals or all these proposals, but we probably have to discuss about it. Thank you very much.
Thank you so much, Thibault. It was a fantastic overview and a very thoughtful discussion of what happens actually to the judge now that we have all of this out-of-court procedural machinery that the DSA brings to the table. So great way to set the stage for the further discussion, and we continue with Emmanuel Netter, who studied law in Strasbourg, defended a PhD, and then started teaching first at the University of Picardy, and since 2018 as a professor at the University of Avignon. Emmanuel, you have the floor.
Thank you. I don't know where I have to press for my slides. Oh, okay, it's completely automated. Thank you very much, Florence, for inviting me. Thibault gave us a very broad perspective on the DSA, and I will go back to a more narrow topic on the internal complaint handling system provided for by Article 20 of the DSA, which has been discussed a few times this morning. This is a second level of moderation inside the platform, and as the title of my intervention says, my project was to collect the platform's point of view on this mechanism. How did they intend to implement this mechanism? What should the second level bring compared to the first? Should the moderators be more experienced, have more time, make collective decisions? I wanted their point of view, and I had reason to be optimistic about my ability to get answers, because I am a researcher. I have a good long-standing relationship with some of these actors, but this time they remain silent. I contacted around 20 professionals. Most simply didn't react. Some told me that they had to ask for approval before answering, then no longer responded despite my reminders. I even clarified that I could keep quiet about the exact identity of the platforms that shared their vision, but that didn't change anything. Let us try to see useful lessons in this failure. My slides are lame, so feel free not to look at them, because I'm very bad at making slides, but it's your choice, be free. The DSA places great emphasis on the concept of transparency, but here I encountered a certain opaqueness. It is true that Article 15 of the DSA, Transparency Reporting Obligations for Providers of Intermediary Services, is quite summary. Regarding content reviewed following a user's notification, there is no indication of the quality of the review process itself. We only have data on what is submitted to moderators, number of notification, type of illegality, and on the result of their examination, what enters and what exits, not what happens in the middle. Curiously enough, for moderation actions initiated by the platform, we have more precise information, such as, quote, the measures taken to provide training and assistance to persons in charge of content moderation. Article 42, on the other hand, is more detailed. Its transparency obligation only applies to very large platforms. It includes, in particular, quote, the human resources that the provider of very large online platforms dedicated to content moderation and the qualification and linguistic expertise of the moderator, as well as the training and support given to such staff. We would therefore have expected the DSA to lift taboos on the moderation practices of very large platforms. My unanswered questions show that the reality is more nuanced. On the other hand, the French Digital Services Coordinator, ARCOM, responded to me, and I thank them. I asked ARCOM if draft guidelines on Article 20 were under consideration. I was told, in a very interesting way, that it was up to professionals to develop practices first, and only then the authorities to see if this was satisfactory. Such a method greatly delays the moment when we will see things more clearly. I am therefore going, as well, to change the angle of this intervention. I'm forced to. We will ask the question ourselves. What can we concretely expect from the platform regarding the internal complaint handling system? If we take the point of view of the authorities, what could be written in guidelines dedicated to the issue? If we take the point of view of the platforms, what steps must probably be taken to avoid any criticism? It was a common thread of the presentation all day. What do we expect from moderators? Both at the first level of decision-making and at the second. How thorough should the examination be? As has already been shown by previous speakers, in particular Professor Ortolani, we are not in the context of a legal appeal, and there is therefore not the time which would be available to a judge to take the context into account and carefully study the applicable text. For the platforms, the internal complaint handling system is one more service that must be offered, representing a cost and bringing no benefit. It will therefore be a question of going as quickly as possible. However, the approach of the French Constitutional Council since 2004 is that platforms should only act on content if it is, quote, manifestly illegal. If the illegality is questionable, if we are in the famous gray zone content, it does not appeal desirable to the Council for the platform to act because it's too sensitive on a political plan. Conversely, the German NetzDG law was very clear in requiring platform to act even when the illegality was not obvious, simply by giving them more time, 7 days, instead of 24 hours. In the DSA, the approach to what constitutes illegal content initially seems very broad. In Article 3, we refer to any illegality within the meaning of national or union law. However, Article 6 states that a user notification only gives the platform knowledge of an illegality if the reported content appears to be illegal, quote, without a detailed legal examination. The expression is equivocal. For example, in terms of freedom of expression, it may happen that the rule is relatively simple to understand, but that is necessary to debate at length the context of the speech. So it's not very clear, and in this presentation we will explore the hypothesis according to which a more summary examination could take place in the first instance, and a more careful examination in the event of a complaint. Just a word, because it has been discussed this morning, on DSA's theoretical requirements for the internal complaint handling system, and after that, my proposal for guidelines. In the Article 20, how is the appeal triggered? It is open to individuals and entities who feel wronged by an initial moderation decision. This may be a user whose notification has had no effect, or on the contrary, a user whose publication has been censored. The deadline is 6 months from the initial decision. The appeal is filed electronically and is free. What type of decision does this appeal benefit from? These are the decisions which alter the visibility of the content, obviously, but also which cause the suspension of the service, the deletion of a user account, or even the suspension of monetization. What qualities must the appeals have? They must be, quote, sufficiently precise and adequately substantiated. And then, what qualities should moderation have? I quote again, providers of online platforms shall handle complaints submitted through their internal complaint handling system in a timely, non-discriminatory, diligent, and non-arbitrary manners. You heard these words this morning. This is an approach that is now typical of European digital law based on very flexible, broad principles. Here, be diligent. Hence the interest, in my view, in implementing this principle in the form of more concrete guidelines. Just before tackling this task, another reminder, Article 20, paragraph 6 provides providers of online platforms shall ensure that the decisions are taken under the supervision of appropriately qualified staff and not solely on the basis of automated means. So, let's come to the heart of this presentation, our modest proposal for guidelines. The first point would be, in my view, a longer examination. Let's start by stating an idea that may not be unanimously accepted. For the sake of realism, it may seem acceptable to carry out a relatively summary examination of the content at the first level, and in return, commit to offering a more robust examination at the second level. When looking at reports from ordinary users, in fact, they can be extremely numerous and sometimes, it has already been said, of low quality. Please note, this logic does not seem to us to be extendable to reports made by trusted flaggers, which must be reviewed very carefully. An argument in favor of a form of tolerance for a faster first-degree examination, we accept that the first decision can be taken automatically. If the European legislator had wanted a very careful examination of ordinary notification from the first level, he could have confined artificial intelligence to decision support system, but he tolerates them as decision-making tools. This approach has the effect of requiring user vigilance. If their notifications is the subject of a bad first-level decision, it is up to them to react. They, therefore, help to filter the decisions of the first moderators, choosing to bring certain ones to the second-level moderators when they are particularly shocked by the first decision. This provides an indirect and ultimately quite valuable measure of the sensitivity and importance of the issues for each specific case. But we can therefore raise the level of requirement with regard to decision number 2. Second point of these imaginary guidelines, a more specialized examination. Since we increased the level of requirements with regard to second-level moderators, we can hope that they will be more specialized in 2 levels. First, a specialization in a field of knowledge. Without going so far as to set precise categories in possible guidelines, we should not entrust the examination to the same people in matters of intellectual property, online hatred, disinformation, protecting of children in danger, and so on. This principle of specialization is already accepted by the DSA for trusted flaggers. Second, a specialization in what I call a cultural universe. In the transparency reports required from very large platforms, it is already required that the number of moderators be detailed according to the language they speak. This is obviously essential, and relying solely on automated translation of rare languages will not always be enough. But it is also necessary, in my view, to specialize and monitor the content of local cultural or communication practices in order, for example, to detect seemingly innocuous but in reality racist paraphrases, coded messages, veiled allusions, and so on. For example, an English-speaking moderator will not be familiar with the local cultural context of all English-speaking regions. Third point of these guidelines, a contradictory examination. The platform must study, says Article 20, sufficiently precise and adequately substantiated complaints. There will therefore be two opposing points of view. If the first decision led to a user being sanctioned, the user will defend himself. To do this, he may rely on the statement of reasons, which must have been provided to him under Article 17. If the first decision refused a moderation action, the user who submitted the notification will undoubtedly strengthen his argument. But note that Article 17 will not be applicable this time, and the user will perhaps lack information on the reasons why his notification was not followed up. The fourth point, and I'm watching the time. Well, I lost my... You do that for me. The fourth point, and there are only 5, so be reassured, a better reasoned decision. The rationale should be more comprehensive in a decision made at the second level of moderation. Where the first decision was not reasoned, because it refused to censor the content, the second, in my view, should be, at least succinctly. When the first decision was motivated but in an automated manner, the second motivation should include a human assessment which explains even briefly why the operation of the algorithm was judged satisfactory in this specific case. Was the first decision was motivated by a human being and the user provided arguments in support of their appeal, this additional reasoning should be responded to in the second decision. And the last points of these guidelines, the consequences of the examination. If the above conditions have been respected, we can postulate that the internal complaint handling system produces decisions that are structurally more reliable than the decisions of the first moderators. We must then take advantage of this to identify recurring errors in first-level decisions. This should not be a simple option, but should be mandatory for the platform. There are 2 hypotheses. The first moderation was carried out by a human being, or it was carried out automatically. If the first moderation was carried out by human teams, it would be necessary to identify possible analysis errors which would be repeated over time and across numerous individual cases. Let's not forget that second-level moderators are better trained and better specialized. They would then need to regularly produce analysis notes for the attention of the first-level teams, explaining, for example, that under European IP law, content which parodies an existing original work may be legal. If the first moderation was carried out automatically, it is just as useful for the second-level moderation teams to provide regular feedback. Here, this could take the form of new labeling of content that had been poorly qualified qualified by the algorithms. Ultimately, this will produce a sufficient mass of reference content which can be used to train again machine learning systems. It is likely that the most virtuous actors already do this, but it should be mandatory to learn lessons from the internal complete and linked system to continuously improve automated moderation tools if the choice was made to use such tools. That's it for these imaginary guidelines. I would be glad to discuss this project with you when the time comes. Thank you for your attention.
Thank you so much, Emmanuel, for this wonderful presentation. And really, that is a perfect example of what I meant when I said it's up to us to give these provisions life and as jurists to use them. And this proposal for a guideline, I'm sure is something we'll keep discussing after today because it's exactly what we need, I think, with regard to the DSA. So thank you so much for this excellent presentation. And we have one last presentation for this panel, and it is a duo. Leonel, Constantino Ferreira, who is a PhD candidate here in Neuchâtel at the LexTech Institute, dealing with due process in digital dispute resolution, together with Jonathan Bory, who is a lecturer here in Neuchâtel, and also a practitioner advising people and companies on legal strategy, contract negotiations, and dispute resolution. Now, I am a music fan, and it's a dumb thing when you go see a band that the band enters the stage first and then the singer comes at the last moment. And this is what this band will do. So Leonel will start the presentation, and then Jonathan will come in a couple of minutes and join the band. Please, Leonel, you have the floor.
Yeah, thank you very much for the kind introduction. Jonathan was supposed to present the first part of this presentation, but I will take the lead and begin by the second part of the presentation. I don't know if my presentation, yeah, okay. So today we'll talk about the regulation of large communication platforms in Switzerland. There is a project, draft bill for consultation project that is currently being drafted by the DTEC, Department of Economy, Transport and Communication, but it has not been yet released, so I will talk about this press release and begin by the second part. And Jonathan will close this speech with the first part. So in the first 10 minutes, I will discuss the existing and future legal framework regarding the regulation of online intermediaries and specifically social medias in Switzerland. First, I will highlight the current hands-off approach of the Swiss legislature regarding the regulation of online intermediaries, contrasting it with what exists now in the EU with the DSA. Then I will present the main aspects of this project, of this draft bill for consultation that has not been yet published, to adopt new regulations on communication platforms. So unlike the EU, Switzerland currently has no specific rules regarding the regulation of online intermediaries and social medias. We have no specific rules regarding the so-called intermediary liability, the liability of platforms for content posted, unlawful content posted by users. And instead, the activities of online intermediaries and social medias are covered by general laws, including, for example, personality rights protection and criminal law, general criminal law. According to a report by the Swiss Federal Council published in 2015, a case-by-case consideration by courts based on this general and existing regulation was deemed preferable and sufficient. Additionally, there is no specific regulation concerning platforms' content moderation practices. However, Swiss copyright law, the specific Swiss copyright law, imposes a so-called stay-down duty on hosting providers for content they store that infringes copyright. According to Article 39D of the Swiss Copyright Act, hosting providers, for example social medias, must ensure that infringing content, copyright infringing content, remains removed once it has been taken down. So there is a first takedown of the unlawful content, copyright infringing content, and when this content, this unlawful content has been removed, it must stay down afterwards. This stay-down obligation has a limited scope because it only targets specific content, namely content that infringes copyright. According to the Swiss legislator, existing regulation fails to account for the specificities of online intermediaries, large communication platforms and communication platforms, such as what we have to speak about this morning, their substantial impact on public debates and their transnational operations. Due to these reasons, the Federal Council has mandated the DTEC, Department of Environment, Transport, Energy and Communications, to prepare a draft bill for consultation on the regulation specific of communication platforms. Initially, the draft bill was supposed to be published by the end of March this year. However, according to sources within the DTEC, the draft bill for consultation will only be published by the end of this year. But we have some information in the press release, and I will summarize it and see if it's the same as it already exists in the DSA. So regarding its scope of application, the new law will apply to communication platforms and large communication platforms. In its press release, the Federal Council highlighted the necessity of regulating specifically large communication platforms such as Google, Facebook, Twitter, and YouTube. The notion of large communication platforms likely corresponds to what exists in the EU, the concept of very large online platforms and very large online search engines. However, the notion of communication platforms and large communication platforms should be further defined by the DTEC in its future draft bill for consultation. The new regulation will be based on the European DSA. It will impose specific due diligence obligations on communication platforms, including transparency, recommendation systems, content moderation, and dispute resolution mechanisms. The draft bill adopts a so-called procedural approach that Professor Ortolani have developed in one of his papers regarding the regulation of the DSA and content moderation disputes. This approach aims to create new channels of dispute resolution for users, and it will require platforms, online intermediaries, to implement or adapt their mechanisms for content moderation and dispute resolution. It will also give Swiss users procedural rights in their interaction with online platforms and specifically social medias. First, the new law will require communication platforms to implement notification and action mechanisms. These mechanisms should allow users to report unlawful and harmful content similar to what exists under the DSA, Article 16 of the DSA. Additionally, users whose content has been deleted or whose account has been blocked should be able to request a review of the measure directly from the platform. This corresponds also to the obligation of setting up an internal appeal mechanism as outlined in Article 20 of the DSA. In its press release, the Swiss Federal Council announced the creation of an arbitration board in Switzerland to resolve content moderation disputes. The English version of the press release uses the term independent arbitration board in Switzerland. However, the French and German version of the press release refer to it as a conciliation board, organe de conciliation and Schlichtungsstelle. These differences between the notions create some uncertainty about the binding nature of this body, and it remains to be clarified whether it will function more as an arbitration or a conciliation mechanism. But the difference between those two mechanisms are crucial. If the board is an arbitration system, it will have the power to impose binding decisions on the parties, so the user and the platform, which could be then theoretically recognized and enforced by state courts as arbitral awards. On the other hand, if it is a conciliation board, in my opinion, it will be a conciliation board, it will not have the power to impose binding decisions on the dispute on the parties. In this scenario, the board can be compared to an ODS, out-of-court dispute settlement body, as defined under the DSA. Furthermore, the Swiss legislator might consider introducing procedural guarantees similar to what exists under the DSA. The draft bill should, for instance, include an obligation for platforms to provide a statement of reasons for their content moderation decisions. So it was the, sorry, I can go back. Okay. It was our conclusion, but I will do it afterwards, maybe. And Jonathan can take the lead.
Jonathan, I have introduced you before you arrived. Very nice to have you here. And, well, it worked perfectly like that. So without further ado, please, you have the floor.
Thank you very much. I'm really happy to be here. I'm coming to talk about the blank page we have in Switzerland. I'm really happy that I can follow the certainly brilliant presentation of Leonel Ferreira, with whom we work together. I was giving a workshop in the mountains the whole morning, so I did my best to come as fast as possible. I didn't eat anything, so if I faint, you're gonna catch me. I'm really happy to be here. We'll take some distance a little bit from the content moderation. My goal is to think a little bit more broadly on what are the risks in social media platform dispute resolution and what are the visible disputes. It's very visible when there is a content moderation dispute. Someone got, I don't know, an account deleted and has the right to oppose, to dispute that decision. But it's invisible when someone is suffering, is hurt from, for example, political polarization. It's less visible when someone is following subjects on diet and suddenly is following videos and pages on anorexia. So what I'm interested in is more, because they are the expert on content moderation, is more to look at the invisible disputes where it's really complicated to have individual rights to fight the problem of political polarization, and the state has to step in to defend the collective interest to protect the individuals who are not able to fight against those things. Okay, so what I want to start with is we need content moderation, but it's not sufficient. We need content moderation, of course, and the work that is done by AI and by humans is very important to protect the users of, I'm really focused on social media platforms, the users of social media platforms against, I don't know, if they don't want to see that pornography, if they don't want to see other content that are in there, that are, I mean, I like the idea of illegality, and also things that are in their general principles, in the terms and conditions that would be prevented. So it is necessary to have content moderation, but it's insufficient for the subject I'm interested in, the question, for example, of political polarization. Okay. Why is it insufficient? It's very complicated to be able to moderate content which will be, for example, hateful, but in a very nuanced way. There are a lot of gray zones. It's very gray, actually. For example, if you are using irony, if you are exaggerating a situation, if you are, for example, taking one case and making it a generality, those situations are very complicated to tackle through content moderation. So we need other aspects, and that's what I'm interested in when we think about it. In Switzerland, when we look at different possibilities to regulate the social media platform. I'm very interested in what I've seen a few weeks ago with the Commission opening formal proceedings against Meta and especially Facebook and Instagram for situations where they didn't assess properly and didn't mitigate the risks related to minors consuming social media. It's very interesting because, for example, someone who's, even me, I would say the metaphor we could use is I'm very seduced and I cannot resist Nutella. If I have Nutella in my kitchen, I'm gonna eat it. So I need to remove that from my site. Okay, I need to not buy Nutella in order to be able. So I cannot trust my free will. I need to have another approach, which is more a behavioral approach, or is more an approach by infrastructure. So what I want to assess and to analyze here is, I think there is a lot of power in the project where they will assess and they will receive report on assessment and risk mitigation. And we are really looking from Switzerland, we are looking at it as I would say, an amazing piece of legislation which put the spotlight on big issues where now we want to see how it's going to be implemented. Now, we're really curious to see how it's going to be implemented. And when I see that, first of all, I see that there was Facebook and Instagram were not too preoccupied to make a perfect report, so they tried to be a little bit of free riders. But I'm happy to see that the Commission is taking action. And we're really looking forward to see what's gonna happen for those systemic risks. I wanted to quote, and we look at European Union, but in Switzerland, we are in the délégué Ferreira thoughts, reflections. We are thinking about what we should do in Switzerland. And I was listening to this guy who's called Tristan Harris. I'm sure you've heard about him. He's the president and the founder of the Center for Human Technology. And he has been named, he has been called the person who has a conscience in Silicon Valley, and the consciousness of Silicon Valley. So it's like coming from civil society and fighting to defend the rights of the users and the people who don't have a voice against the big tech. He's quite oftenly assimilating big tech with big tobacco. We need to have strong measures in order to be able to offer checks and balances to big powers. So I think it's very interesting, and he was mentioning TikTok. And TikTok in China, the equivalent of TikTok in China, same mother company, is blocked from 10 p.m. to 6 a.m. So we cannot use TikTok at on these hours. So there is kind of like in my kitchen with the Nutella, we remove the Nutella from the sight of the people so that they don't have this, we need to acknowledge that there is an addiction risk, so we need to remove that. And it's a strong political decision. And then the other thing is they influenced the content. So it's not content moderation, but it's content promotion. It's content promotion, so they want to promote educational content. So instead of looking only at girls dancing and anorexia and then fights in clubs, or like in my case, they're really good at targeting me, they would show the 10 best goals of Lionel Messi. Then they would show the next comic who's absolutely funny, and I cannot stop watching. And then after that, they really targeted me like properly. But then we would have educational content that is promoted. That's a question, as a society, we have a program for universities. We have a program for schools. We are influencing the content that people are spending time in front of. So there is a question, should we consider this, or is it coming from China, or should we discredit it? Should we not consider it because of the source and the government, which is authoritative? Or should we consider an option, a regulation option, a public policy that we could consider, which would be stronger, but maybe as well more effective than content moderation? So I just wanted to read this sentence. It's almost like they recognize that technology is influencing kids' development and make their own domestic version of a spinach version of TikTok, while they ship the opium version to the rest of the world. So they are shipping opium very addictive algorithm. That's crazy. I mean, I don't know if some of you are on TikTok. Are you? Who's on TikTok? Okay, a few people in the room. It's crazy how you will realize that you have lost suddenly 45 minutes watching things you don't remember afterwards. So that's like a trap. I feel like trapped when I go there. And that's interesting to see that they saw this problem, they're offering spinach to make them stronger, and the rest of the world can get the risky algorithm. I wanted to shift a little bit the perspective and really think about the content moderation and how we should try to think from the ground up what we are doing with the social media platform. And that's a conference that took place a few days ago in Brussels. And this conference was really interesting. The title was, for me, was really to the point. Social media recommender system should deliver value, not user engagement. So we have an issue with the business model of big social media platform. We need to think about what's this business model. The business model is optimizing the recommendation system, the algorithm for screen time. It's optimizing for obtaining information on the users in order to sell better advertisement. So we need to think about what we want as, because you know, Instagram, TikTok, it's a place where the public goes, where things are discussed, and it's more like a mall where you have a lot of shops than a town square where you have people being able to talk to each other and to look at each other without being polarized. So I think this is I would love to see that, but I'm not sure Switzerland would be strong enough to propose something different than European Union. We know that there is also a balance of power. We know as well that those social media platforms, they also provide a lot of value. I mean, personally, I learn much more on YouTube than at the university. I have to admit that. I learn much more with podcasts on Spotify than at the university. And I'm interested in the way we could think about a public town square where we could be able to talk to each other without being polarized. We have a world, we are sharing a same world that we can discuss about without attacking each other. And I'm going to arrive to the end of this small presentation, and I wanted to talk about the fact that no human or AI can catch polarizing content quickly enough, because it's optimized for user, for screen time, it's optimized for engagement, and it's optimized for virality as well. And they have to compete. I mean, Instagram is competing with TikTok, and that's where we saw the Instagram Reels arrive. And and also I think we need to think about education, what we could do in terms of education to build stronger critical thinking. This is one of the topics I'm very interested in, and I'm gonna maybe if we have the time to talk about this. Rather than optimizing for engagement and then corrective negative externalities, I wanted to suggest I would say a legal framework which is a bit stronger in order to make sure they are built for human dignity and social cohesion from the ground up. Thank you very much for your attention and for accepting me, even if I'm late.
Thank you so much, Jonathan and Leonel, for a wonderful presentation. And of course, Jonathan, best of luck on your crusade against Big Nutella. It's something I also suffer from. Florence, shall we open the floor for questions?
Yes,
Do you want to take
we
over?
shall. And I invite Naomi Appelman and Manuel Vargas to join us on the stage, because it would be interesting to have both of you here. You are going to have a chair because I'm leaving mine.
Okay.
So no problem.
All right, so while our two extra panelists take the stage, I already have a question from Anya. Let's start from that, please.
Thank you very much. Since I'm a lawyer at heart, I jump on the judge. Interesting. whether DSA is actually abolishing the role of the judge, if I exaggerate a little bit. So if I if I think about it, what is the scope of the DSA? We talk about social media, but does this kind of cover the whole online world? We just learned about all these different fora, like large groups like Telegram. So is there some, let's say, crumbs left for the judge? That's one thing. And then if the judge is actually, seeing a case, what you mentioned, national laws, is in the framework of the DSA, if I jump back, is there something on conflict of laws? I think there's a discussion about that. So what is actually the standard of review then? And then at the end you said it's slow, but perhaps you can say something about preliminary injunctions. Thank you.
That's a big question. The scope of the DSA is broader than online, than social media. DSA covers Alibaba, Booking, or other this type of website. For Telegram, we don't know. If Telegram, I don't know if. What do you think about it?
I don't think that Telegram falls under the scope, but under the control of all my colleagues, because you don't put content to be publicly available, and that's the criteria for a platform. So when it's social media, it's at least for your friends, and sometimes you want your content to be publicly available. On encrypted platforms like Signal or WhatsApp, it's only for your contacts, maybe a few contacts, but it's not the same logic as in a social media, in my view.
Just to say that I partially disagree, because Telegram also has the Telegram channels, which are publicly available, and it's more similar to social media.
WhatsApp and social group on WhatsApp could fall under the DSA too, I think. But it's if we exclude the DSA when we look at the DMA, under the DMA, Telegram, WhatsApp fall under the DMA. There is no discussion about it, but for the DSA, it's a question. The evolution of these services pose a question for the scope of application of the DSA.
Well,
for the conflict of laws?
No, almost. So we are talking about the scope of the DSA, and I was just wondering, what do you think about Switzerland? We don't have any legal situation yet, so we don't have any law yet, but what is the situation in Switzerland for the Swiss users? Are they protected by the DSA or not? We are talking about the extraterritorial scope.
Yeah, I mean, we already addressed the topic throughout the day. There's some signs of a Brussels effect, right? Because eventually platforms want to minimize compliance costs, and they want to offer a service that's as universal as possible within the limits of legality. So I think that certain types of content moderation practices will eventually be DSA compliant also outside of the EU, probably, because otherwise you would need to instruct moderators to work into different ways, depending on where the content comes from, which is not really smart, I think. However, there are other cases where already we see a certain fragmentation. And the most obvious example is that now you have, in fact, on many platforms, 2 notice and action mechanisms. One of them that's not required by the DSA, and it's for lawful content that's against the terms and conditions. And by the way, that's what does most of the job in practice. And then another one that is for EU illegal content, as they mentioned, with a massive overlap with the terms of service, and that is not available outside of the EU. So it's a bit of both, I think, in the current landscape. I don't know if you have other experiences.
And you mentioned the EU illegal contact. So what does it mean exactly? When we say it's illegal under EU law, and I think that the DSA says somewhere EU law and national law.
Absolutely.
So what is it? Is it the law of the forum? So each judge is going to apply the law of his own state, which means that maybe one content would be illegal in one state and not in another one. So it depends on where you introduce your proceedings. Is this the reality of this DSA, or is it different?
Yeah, so essentially the whole procedural turn that Leonel was also talking about, in my opinion, has been triggered by this attempt to regulate the problem while eschewing the elephant in the room, that is, what should be legal or illegal online, which is an intractable problem, because if you think of certain case studies, for example, depictions of homosexuality, there are member states in the EU where that is illegal in certain types of media, for example, media for children, but other member states where, in fact, it's illegal to discriminate against those type of discriminations in media for children, right? So on the substantive level, the vision is extremely different or significantly different in different member states. And the DSA basically takes a very hands-off approach and says, if it's illegal under EU law, then it's illegal. If it's illegal under a certain domestic law, then it's also illegal, but it doesn't tell you, of course, under which law, which in turn requires the platforms to apply, I think, the Rome 1 and the Rome 2 regulations, right, to determine which is the applicable law. And it's not always going to be the law where the forum, in this case, doesn't exist because we're not in front of a judge, but the complainant is located. This is something that I will add is a problem with respect to the DSA, and in general with the fact that many new instruments don't have any type of consideration for private international law. But in general, it is a problem with European private international law as a whole. If you look at jurisdiction, we are still working with a system that basically dates back to the 1968 Brussels Convention. And it tells you that, for example, for tortious cases, you can sue wherever the harmful event occurred. And the Court of Justice has told us it's wherever the direct effects of the conduct are felt. Now, when it came to pollution on the River Rhine, that seemed to make sense. But now with defamation cases, that is very impalpable. So I don't know if the solution is to add, in all of these new instruments, provisions on jurisdiction, on applicable law, and so on, or whether we need to rethink that field of law. Now we're reviewing the Brussels 1 bis regulation once again. Maybe the harmful event is something to be discussed again.
Yes. So for the time being, we just have to file the claim before the right forum and hope that it's illegal and ask for a lot of money there because we cannot get more money there as in another country. That's the point, yeah. As always in private international law, yeah.
Thank you. Yes, amazing. To add to that, I think we should not forget the dimension of the competencies of the EU to begin with, right? Because we are framing this entire discussion of the Digital Services Act and content moderation as some grand effort to protect human rights online, and that's just simply not what this regulation is and what the EU is here to do. We're dealing with basically consumer law, but not. To address problems concerning public values that we want to address, and this is one of the issues I think we continuously run up against, that these instruments are just simply not equipped to address these problems, and the EU is simply not, does not have the competencies to create the substantive safeguards and substantive rules that you would want, so you will have these very complicated, messy country of origin principles that the DSA is not original to, right? So the same you have with audiovisual media directives. Yeah, so I fully agree with this, that it's one of these core problems that you keep running into.
I was just wondering about the question about WhatsApp and Telegram, and maybe it falls under the other categories of intermediaries of the DSA, maybe, I don't remember the name, mere conduct or cash services, because the definition of mere conduct or cash services, I don't remember, covers, for example, system of IP voices, and WhatsApp will be one of these intermediaries, but I'm not sure about my answer.
For messages, it's a good argument. I think for groups, especially for Telegram, I mean, these groups are basically huge, and they are used to publish stuff that is of debatable legality, but certainly wouldn't be allowed on Instagram or X or you name it, TikTok, and that's why they go to Telegram. But in practice, if you look at the nature of the service, it is a hosting service, I think. But that's my gut feeling.
Thank you. And maybe coming back again to the Telegram question, I guess that it's also important to look at recent developments at the European Court of Human Rights. For instance, if we look at the Sanchez versus France case, we see that the European Court of Human Rights has seen that users with some gateway power, like the administrator of a group, etc., have some responsibilities of removing content, of acting against content. So even if WhatsApp is outside of the DSA in terms of a platform, a social media platform, there may be some responsibilities of people who are administering these specific groups.
Okay, so I have a question to all of you, and maybe someone in the audience, because it's a quite new instrument. So you know maybe that 2 weeks ago, the Council of Europe adopted the Convention on AI and Human Rights. And in this new international instrument, that is the first one about AI, there is an Article 15 which concerns procedural guarantees. So I'm sure that you all know this article. And well, anyway, under this provision, contracting states must make sure that people enjoy effective procedural guarantees in accordance with international and domestic laws when an AI system significantly impacts human rights. Significantly impacts human rights. And this article also says that every person interacting with an AI system shall be notified that they are not interacting with a human. So my question is, what do you think? Will it reinforce procedural guarantees in the case of content moderation on social media? Or does it simply repeat rules that are already in force?
There's two layers to this, I think. One of them is the transparency layer, and that's in itself, I think, a fundamental guarantee, but it only goes so far. And it is knowing that you're interacting with AI. And that is, in a way, a new type of right, a new type of guarantee. You find it also in the AI Act with respect to chatbots, for example. It does not really ensure, per se, a higher level of protection, but maybe a higher level of awareness in your ability to protect yourself or decide not to interact with those tools. But it doesn't say anything about how those mechanisms work. For the rest, you know, AI has such a broad scope of application that in some cases that might just be a reiteration of guarantees you already find. So for example, people always think about the robot judge and using the judiciary. Well, in that context, you already have Article 6, you already have constitutional law, you have already plenty of reasons why it's already prohibited without going to Article 22 of the GDPR, which is another reason why you cannot have fully automated decision making. But there might be new settings where those guarantees don't apply, and this instrument does add something. So I don't think it's purely a publicity stunt.
I agree with Pietro. I see that it may be some degree of repetition, but it's also something that can be useful for protection, like to have this written on paper. But the other thing that I think is valuable from the convention at the Council of Europe is that it's open for adhesion by countries outside the Council of Europe. So this is something that could be a standard that can reach other places, not by the transposition of the DSA, of the AI Act, by local legislatures, but actually by countries from outside of Europe who want to have some international background to their own internal legislation, right?
So, question to Leonel, Constantino, Ferreira. Do you think that if Switzerland ratifies this convention, we are going to need new legislation quickly, or is it just going to be enough for us?
First, for the legislation that I mentioned, the draft bill is not yet published, so the legislative process will take time, and we will not have a specific law before 2027 or 2028. And about AI, we have nothing special in Switzerland, but ratifying this convention, we spoke this morning about the horizontal effect of human rights, and this convention should be applied by the contracting parties to private entities. So there is this horizontal effect that will be applicable in Switzerland as well. So we don't need, I think in Switzerland we will not have a specific framework regarding AI, but...
Can I ask a follow-up question about the draft bill? Because when you were describing it, I found a difference with the DSA, but I want to make sure I did not misunderstand. If I understand correctly, this out-of-court dispute settlement, which might be arbitration or conciliation, we don't know yet, it's just one, so it's a state that sets it up. It's not possible for private entities to be certified. It's one single authority.
Yeah, there is no such economic certification of ODS as it exists, as it will exist when it exists in the EU. And I met someone in the audience this morning that wants to set up one of these ODS, or is involved in this ODS, and maybe you can add something about your project.
If you want, it's not mandatory.
If you want, yeah. About your project of setting up, be certified as an ODS in the EU.
Yeah, sure. So basically, as a body, typically you might have some expertise in a certain area of content, or you might have worked at a platform before, and then you'll approach the national level regulator, which is called a Digital Services Coordinator. So hypothetically, we would do that in Ireland because, you know, we're working in a UK company where English is the only language. And then you just enter a process in order to get your certification. So you have to satisfy 6 or 7 conditions, such as your expertise, your independence, that you have fair rules of procedure, just a sum. And then once that is approved, it's quite an arduous process. And I think, as was already given in other examples today, it's kind of like it's being developed as it goes along. Like, it's not like the regulator is saying to these companies, this is what you have to do. What we've encountered and what other, academics also have mentioned is that it's kind of like you're going with something and then the regulator is reacting to it, as opposed to them having their own set standards. So it's very much like an ongoing process, but then after a certain amount of time, they either send back the application and you get your certification, or they say, well, you might need to change X, Y, Z. So then it's like it's very much like a collegial process. It's not like in any way combative, I guess you could say, combative. So yeah, and then after that point, I think there's like a period of, you're not going to be operational immediately. So then it's like once you have that certification under Article 21, then you have like, I think it's informally saying like it could even be at least a year, 2 years, in which then you can actually start receiving complaints from users. But aside from that, all the other information is within the DSA in that Article 21, and then the Irish regulator has put out a like 10-15 page application form which has like some information but not nearly enough, because like previously in writing about this or like informally talking to other people that are entering this space, they were hoping that at national level, because they're going to be overseeing this far more than the Commission, that it would be like the Irish or the French or whoever else, the Germans, that would then provide extra information to say, okay, well, this is what we mean by independence, this is what we mean by expertise, these are the areas in which your expertise need to be, but this is completely left open, which is just typical of EU legislation because it's applying to, 450 million people. But yeah, that's the general process.
Do we have a question online? No.
I don't know, but...
Yes, there is one. It would be wonderful if we could get it on the screen in front of us, because it was the idea to put the screen there.
So the first question is, what resources beyond legislation of disputes do we have to claim democratic oversight and governance in privatized digital public spaces? So... And there is also an additional comment. Here I am referring to democratic innovation and reclaiming democratic principles in spaces that have been taken over by corporations and property rights. So someone very interested by corporations. I guess it's the same also as earlier today.
I don't know who dares to. Yeah, please go ahead. I don't dare to answer these questions.
Many thanks for this very bright and broad question. So I can maybe provide an idea. I think there are many ways. There is not only legislation, the proper legislation. There is also, I think this morning, there were discussions about grassroots movements. There were also discussions about the role of civil society. There are also discussions. There is legislation, but then there is also collaboration between the platforms and the European Union. They have discussions. We have seen a lot, and that was not very convincing, but we have seen a lot of good practices or code of conduct. And I think those approaches are also very important, that we keep a discussion between the regulator and the different actors. So there is, I would say, legislation is one thing, but then you can convince them by public opinion, try to convince them to change their terms and conditions. You can also collaborate with them. So I think there are the three ways: constraint, convince, and then collaborate. So the three C's are three approaches. That's in a very interesting book about politics of platform governance. This is one thing I would bring to the table.
Perhaps if I read the question in a slightly different way, so beyond the legislation of disputes, right? We're focusing on content moderation, but that's not the only element of these corporations that can be regulated. And I think one theme that I saw throughout a lot of the presentations and discussions today was the role of corporate interest in how to resolve the tension between the corporate interest and the public values that we are trying to safeguard here. So another element that you could take is regulating and legislating these corporate interests. And one very clear way of doing so is regulating targeted advertisement. And this was something that has been proposed time and time again and was on the table for the DSA also, but was very clearly shied away from doing, not for any legal reason, but purely ideological reasons, for not, like, there's just not the political will to regulate these companies in this way. But that very clearly, to me, is an option if we do agree that the corporate interests intervene in what we want them to do for public debate in an irresolvable tension, because personally I do not really believe that forms of self-regulation will resolve that tension.
And something that I would like to add in the lines of that question is I mean, these are points that can be seen in different legislations and policies that are not within the DSA, but are quite linked to the purpose of having like a favorable and friendly environment of discussion and public debate, and it's media and information literacy. Like it's critical to have actual policies teaching people of every age and ethnicities and different levels of education to know how to engage with social media, with content and with the disputes that may arise and maybe don't have to be solved through complaint handling mechanisms or dispute resolution mechanisms. And the other point that is critical from my point of view is something that was raised by several organizations in Latin America recently when they were going against regulation of social media, and is basically working in more policies to actually attack the reasons for these content disputes arising. Like basically, if there's a lot of hate speech and discrimination online, what you have to do is actually to raise awareness against hate speech and discrimination within the society, and not necessarily just focus on taking down the content from social media.
We have one more question online.
Yeah, can I maybe ask one myself as I grab the mic? You made, Jonathan Bory, a very interesting distinction between what we could say harmful content versus junk content, maybe. By junk content, I mean those addictive, very addictive content you were referring to when you talked about Tristan Harris, for instance, reflection about the Chinese policy about censoring widely in their borders and allowing a lot of junk content to be disseminated around the world. So if we frame the question this way, in fact, I think we could distinct the question of what we call public order public, the core societal values, and distinguish it as the key element for the criteria for what is harmful content. The problem then is, it is widely known that we are not in the 18th century anymore, and that we are well aware that core societal values are very, very, very different according to the regions. So how do we deal with this relativistic framework of ideas? I don't want to name names, but of course there is a very big challenge to be addressed here. I know we have heard a lot about it today, but maybe there is another question or another way to see it now, that we have this distinction between harmful and junk content. The other question being, what about junk content? Is there some specific legislative process or reflection about censoring or monitoring this kind of content? Thank you.
Thank you very much for your question. I can try to understand what you mean by junk content. I think it's very important to get back to what's a social media platform, what's its business model. And there was this sentence that I like with, it could be lawful but harmful. Lawful but harmful. And we need to analyze it's very complicated to determine what's harmful. There are very clear situations, but there are also gray zones. And also it's complicated to look at it in abstracto, you know, like this is junk content, sorry. There are clickbait, there are things we can analyze and that even AI can analyze. But there are also many things, and I wanted to mention that are very gray, and it could be irony, it could be a little bit of exaggeration, it could be a very slight and nuanced, I would say, content that overall will bring people like further from each other, and that's what I think is if we don't have, if this is the big topic of echo chambers, you know, when you are in your bubble, you are convinced to be right, and we've seen that in many political campaigns. We've seen that. I'm interested when you just said about like corporate interest. How do we regulate corporate interest? Advertisement. How do we regulate political advertisement? And for me, junk content is not easy to define. It's not easy at all to define what's junk content. When you say addictive,
thinking about shorts, for instance, or reels.
Sorry?
The reels that you have on your feed,
Yes.
for instance, in Facebook or.
But for me, there are many reels that are very interesting. I'm learning a lot from reels. I'm happy to have 1 minute content or 30-second content about the situation in Palestine. I'm very happy to have 1 minute content about the next business model of, I don't know, the next AI from Elon Musk. I'm happy to have, so it's complicated, and I'm maybe joining what you said before about education. We need to develop a healthy approach to how we're gonna put parameters to content, and I'm trying to make my feed very interesting and very intellectual, but it's not easy. It's a challenge, and I think when you look at, for example, young people who are attracted by junk food and junk content, it's complicated to take some distance from the Nutella and go for the chia seeds, you know? So, and we need to think in ways of education, but I think it's not enough education. It's not enough because there are so many, you know, education is complicated when you're fighting against meta. When you're fighting against meta, you're fighting against neuroscientific, psychologists, excellent economists. You are fighting against UX designer. You're fighting against a big team who's making the product as attractive as possible because their business model is to optimize screen time and optimize for you staying on the app and read the ads from the corporate interest. So it's complicated to define junk food, and I like this idea. I think it's a challenge, and that's a challenge we need education, but it cannot be solved by education. I think one of the DSA proposal where I think there's a lot of potential, but we need to see, that's what I was mentioning, is identifying systemic risk, assessing systemic risk, and then proving that you are mitigating those risks. Okay, how are they proving that they're mitigating the risk that we spend too much time on our phones? You know, there was a very interesting association launched called Time Well Spent. I like this idea. How do we think about how we spend our time? What's time well spent? And content moderation can do a lot, but that cannot be the only way we are attacking this, because it's kind of the old way of looking at it, with people having time to dispute a decision, having time to go to this kind of internal court, and then to go to this out-of-court settlement. And there is a question of effectiveness and of how people are ready to, going to court in Switzerland, nobody does that. Even if we have like trustworthy institutions. And there was this sentence I love called, we have Paleolithic minds, medieval institutions, and we have Paleolithic emotions, medieval institutions, and godlike technologies. So what does this sentence say? It said our institutions are not ready, technologies are too powerful, and we are still sensitive. We cannot see human beings as Homo economicus. We need to see them as they are, Homo sapiens, and with their biases, with their incapacities. So, and I think that's a big step forward. The DSA, I'm very impressed actually, and I'm looking forward to Switzerland moving and trying to because I think it's a big spotlight on the problem, and there are many very important issues raised, and still I think it's not sufficient, and we need to have a more systemic approach, but maybe we have a lack of information, and this, like access to algorithm, that was also the big black box, this algorithm, this recommendation process, and now access for scientists, and so I think there is steps forwards, but there's still a lot to do.
I wanted to add something there. I just wanted to say that maybe the junk term is problematic because, of course, there is a need to act against content that is awful but lawful, but there's also content that is harmless and irrelevant, right? And there is also, of course, it's important that social media and communications are used for people being better individuals, better citizens, but there's also a right to be silly, and there's also a right to see reels that are not contributing to your education, but maybe that are contributing to your happiness, right? And what I think that maybe is relevant is not looking at the content per se, but at the potential of harm that it may have, right? So an example that I can think of is, for instance, there was a case in the Rwanda tribunal against a singer. The singer made really awful songs against the Tutsis, if I'm not wrong, and these songs per se did not constitute hate speech in the terms of international law, because they were not calling for violence directly, but they were replicating stereotypes and things that were harmful. But something that happened later is that those same songs were used by journalists and radio stations who were involved in other cases in which they were actually calling for violence, and they were instrumentalizing these songs for calling into violence. So this content was, in principle, not harmful, but you can see that the patterns and the ways in which it can be used led to violence. So in the moments in which those kind of scenarios can be triggered or are seen as possibly being triggered in the future, I think that's the moment in which the awful but lawful can be acted against too.
I don't know what time we have left. Maybe it's time for the... You have an answer? So 5 minutes? Oh, okay, so maybe just...
Yes, maybe we are going to take this last question online. Sabrina, please be ready. To what extent is AI being used in content moderation? So maybe I can ask you, Sabrina Ahmad, to just remind us how many decisions are taken each day in the meta environment by algorithmic decisions.
Okay, I wasn't prepared for it, but I'll try and answer it anyway. I would say probably millions of pieces of content are actioned every day in some fashion, either by AI or a human moderator. I was actually looking at this question while you were speaking a little bit, and I was also thinking about there are different ways that AI is being deployed. I'm just going to talk about meta systems very quickly, but for example, in one of our case decisions, we discovered the use of media matching service banks as one way. Meta also kind of uses a dynamic algorithm to determine whether something should be allocated or sent for human review. So even if initially it's an AI looking at it, there is like a very dynamic kind of calculation that's made as to whether that piece of content should be deployed for human review. In one of our case decisions, we also actually found that during COVID, many of the decisions that were being made were automatically being closed by AI because the human moderators were not allowed to go to their offices. And so that actually posed a very big problem as well. So I think that's a big indication as to the fact that AI is being used quite pervasively in the moderation ecosystem. And yeah, hopefully, I didn't give you an exact number because I don't know it myself personally, but I hope that gives you kind of an idea of the scope and the scale of how AI is being used in content moderation.
Yes, it does, definitely. Thank you very much, Sabrina Ahmad. Well, I think we can bring it to a close.
Absolutely, yes. I say if no other co-panelists wants to add anything, then join us in a round of applause for our speakers. Thank you very much.